All right, let's get going with this. There we go. Okay, good afternoon. My name is Jeff Moffitt. Welcome to today's presentation from the Employment Standards Branch. For those of you who are not already WorkBC clients, WorkBC offers free services and supports for anyone not already enjoying long-term sustainable employment. Your WorkBC case manager can help you connect you with the right employment opportunities and to provide the coaching, workshops, training, and funding to be the best applicant you can be. Call us today at 250-388-0858 or visit your nearest WorkBC center in person to find out how we can help. Before we begin today, we respectfully acknowledge the Esquimalt Nation, the Songhees Nation, the Wasanik people, the Stanaimach First Nation, the Stalo Nation, and the Syilx Okanagan Nation, on whose lands we live, learn, work, and play. Our acknowledgement is sincere. We lift up our hands in respect to the Lekwungen, Wasanik, Stanaimach, Stalo, and Syilx, whose relationship with the land is sacred and continues. We dedicate ourselves to learning about local Indigenous people and culture, to share what we learn, and to listen to and respect Indigenous voices. Haichka. For today's presentation, we ask that you remain muted and video off so we can enjoy a high-quality viewing experience. If you have any questions at all for our guests, please type them into the chat, and I will pose them on your behalf after the presentation is done. Today, we have captioning courtesy of Island Deaf and Hard of Hearing. Thank you, Alice and Marissa, for providing this service. If you would like to access the captioning, you can either access captioning by enabling the closed caption button at the bottom of the page or by the external link that was shared in the chat. I believe it's the first part of the chat there if you go in there. So without further ado, the Employment Standards Branch of the Ministry of Labor administers the Employment Standards Act, which ensures that employees in BC receive at least basic compensation and conditions of employment. Today's presentation is intended to provide you with some of the key aspects of the employment that are governed by this act and what you need to know to be an informed employee. Our guest name is Kathleen Horan, delegate of the Director of Employment Standards Branch for the Ministry of Labor. Welcome, Kathleen.
Thank you very much, Jeff.
Thank you. And take it away. I'll mute myself and watch the chat for any questions that pop up.
Okay, great. Thank you very much. Well, hi, everybody. I'm very happy to be here to give this presentation today. And it's the first time I've done this on Zoom, so I hope you'll be understanding and patient with me if there's any glitches. Hopefully there won't be. So today I wanted to talk about the Employment Standards Act and its relevance to you, as well as all the little bits and pieces in there. I used to give these presentations in person, and I used to make a joke that I wanted to look you all in the eyes as I hired you, made you work for me, and then fired you and explained all the rules along the way. So we're not in person today, but I'll do the best I can. So the Employment Standards Act is the legislation in British Columbia that governs employment. Most people are covered by this act, and it's very important to you because obviously you may be an employee earning wages, or you may eventually own your own business one day and need to know these rules also. Or you might be a manager or be doing payroll, and you need to understand the rules and regulations that are in the act so that you don't get into any little bits of trouble down the way. So like I said, most people are covered by the Act. Employees in British Columbia are covered, and that's employees as defined in the Act. And I'll get into who is an employee and who is not in a moment. But you must be covered by provincial jurisdiction. And what that means is that if you work for the federal government or any kind of an industry governed by the federal government, that sort of cross-border type of work, like television stations or banks or railroads or things like that, airlines, those will be covered by federal, and you wouldn't be covered under us. People who are working under a collective agreement, a unionized employee, they are not covered under the Act because the basic tenets of the Act are already embodied in the collective agreement. collective agreements have to be vetted by the Labor Relations Board, and you've got to have the minimum standards in there. You can't get lower than the Employment Standards Act. We're it. So those basic standards are already covered there. Also, certain occupations are excluded from the Act because they have their own professional organizations, like doctors and lawyers and chartered accountants and things like that are not covered under the Act. So I talked about who is an employee. Well, basically, it's anybody who's receiving or entitled to receive wages for work that you've performed for another. That includes a person who an employer allows directly or indirectly to perform work normally performed by an employee. When I say indirectly, I say that because we have had instances before where, let's say a guy is working in a restaurant as a dishwasher and he asks his friend to come and help him for a couple of hours, and the friend comes and later asks for wages. And the employer says, I don't want to pay you wages. I didn't hire you. But the employer bears the responsibility of monitoring the workplace. And if somebody comes in and does the work of an employee for the benefit of his business, it means that person was the employee for a short time, and minimum wage at least must be owed. Also, an employee is somebody who's being trained. So if you take on a job and there's a couple of days worth of training, and then afterwards the employer decides not to bring you on, he still has to pay you for the time that you were doing the training. You were an employee for that period of time. If you're working someplace and you need to go on some kind of a special leave, a medical leave or something like that, if the employer does not terminate you, then you are still an employee the whole time that you're on that leave, and your seniority continues to accrue and things like that. Same thing goes where it says a person has a right of recall. That means that if you're on a temporary layoff, if you've agreed to a temporary layoff, you're waiting to be recalled to work. And during the time that you're laid off, you're still on the books, you're still an employee because you haven't been terminated. So again, a few more things about who may be an employee. You can work from home, as I mostly work from home and things like that. You might use your own vehicle doing pizza delivery and things like that. Like I said, you might be in the process of being trained, or it's somebody who people believe to be an employee of a business if they're using the business's, equipment and business cards and logos and t-shirts and things like that. And if the general public believes you to be an employee, you may be found to be an employee under the Act if it came down to, some kind of a dispute about it. There are definitions also in the Act about employer, and that is someone who has or had control or direction of an employee, or who's responsible for the employment of an employee. That's the example I gave, about the dishwasher. So we just recently had a very interesting decision about a child who was given a notice to take home to his parents. And so he went home and gave the notice to his father, and his father felt that the school had made the child a delivery person, and therefore he should have been paid as an employee. But a big decision had to be issued about that, and it was found that the school could not be listed as that child's employer because they did not have control or direction. They gave the notice to that child, and the child could do whatever he wanted with the notice. They had no control. There was no repercussions if he didn't give the notice. So, there are sometimes those definitions of who is an employee and who is an employer come into play if there's a dispute and we have to make a decision. Work, there's also definitions of work, and that's basically any labor services that you do for an employer, whether it's in the employee's residence or elsewhere, your residence or anywhere. It's basically anything that you do for the benefit of the employer's business. And work also is when people are on call. There's a few rules about being on call because a lot of people work on call. If you're just sitting at home watching TV and having a cup of tea and waiting for the phone to ring, you're on call, but you're not at work until the phone rings. If your employer calls and said, okay, now we need you, the clock starts ticking then. But if that same employer says, I don't want you to wait at home, I want you to come into the office and just read a magazine in the coffee room until you're called. Well, now the employer is controlling where you're sitting waiting to be on call. And while you're sitting and waiting, you're now on the clock because the employer is controlling your time. If you're at home, he's not controlling your time until the phone rings. But if you're at a place where he deems wants you to be, then you are on the clock. Okay, so we all work to get paid wages. And there's quite a number of rules about payment of wages here. And I always really stress this with employees because people get into a lot of problems and miscommunications and misunderstandings about wages. And it's important you know what you're entitled to and how employers are supposed to treat wages. So for one thing, wages must be paid for all work performed. That means if you get called in on a day off for a 1-hour meeting, well, that's work. If you're asked to show up 15 minutes early to get the work site ready, well, that's work too. If you're doing some training or something like that, that's all work. Anything that you do for the benefit of the employer's business is considered to be work. At least minimum wage must be paid for all hours worked. Wages must be paid in Canadian currency. We've had several complaints at the branch where somebody worked at, say, a clothing store, and the employer said, well, I owe you $1,000. I'll give you 500 in cash and the rest you can take in merchandise. No, it must be in Canadian currency. You can't give something in lieu of money. Okay. And the wages can be paid by direct deposit if you've given your banking information and your authorization to the employee. It can be paid by check. It can be paid by cash. A lot of employers are paying by e-transfer. All of those methods are fine as long as you get that money in Canadian currency. People must be paid at least twice per month. There are still a lot of employers out there who are only paying you once a month. That's a contravention of the Act. You must be paid at least twice per month, and the employer has the choice of paying you on the 1st or the 15th, or maybe the 15th and the 30th, or some employers pay every second Friday. However the employer wants to do, that's fine, as long as it's at least twice per month. Some employers prefer to pay every week. That's fine too, okay? There are certain timelines about when wages must be paid. So if you work 2 weeks, the employer now has 8 days to pay you for those 2 weeks. Okay. And that's important because a lot of people start a new job and they have the idea that the employer has withheld a week of pay because they don't get their first paycheck until they're 3 weeks in. But that's not the case. The employer is paying you for the first 2 weeks you've worked, but he gets a week to do that. So that's why that is. There's also a few other rules about timeliness of payment of wages. So if you get fired, the employer has made that decision to let you go. And because the employer has made that decision, technically they get a fairly short amount of time to pay you. They should have everything all lined up and ready to go when you're fired. So the Act says 48 hours. If you decide to quit, well, that's going to be a surprise maybe to the employer. So he or she gets a little bit longer, 6 days. But those two parts of the Act, when we get complaints, we call the parties and try to find a voluntary resolution. If we find that the wages were paid, but not within 48 hours, then we consider it resolved because you did get the wages. The only time we use these two bits here is if no wages have been paid or the improper amount has been paid, and now the branch has to issue a formal decision against the employer. In that case, there may be some penalties against the employer, and we would be using these two bits here saying, well, you didn't pay within 48 hours, and that means that you get a penalty now. Wage statements, I cannot stress enough how important wage statements are for employees. A wage statement is your legal document to prove that you worked, how many hours you worked, who the employer is, what the rate of pay was. You're supposed to get a wage statement with each payment of wages. And there's quite a bit of information that must be on that wage statement. There's a list here we're looking at, but the hours that you worked and whatever your regular rate of pay is, and any overtime hours that you worked and what the overtime rate is for those wages. Also, some people, they like to bank overtime. Some people have established an overtime bank, so they're just saving up their overtime hours. Well, the amount of overtime hours in your bank must also show up on your wage statement. Any other money that you're entitled to, like accrued vacation pay or statutory holiday pay or any bonuses, all of it must show up on your wage statement. And please, if you are an employee, please keep your wage statements and look at them each time, because employers are human and their payroll people are human, and sometimes mistakes are made. And if you get on it right away, if you notice a mistake right away and you bring it to the employer's attention, it's easy to fix. It's more difficult if it's months and months down the road. So I always tell employees, please look at your wage statement each time and save them, because if I can't get pay records from an employer, I'm going to turn to the complainant, the person who's filing a complaint, and saying, did you save your wage statements? Could you maybe send those to me? So they're very important. Okay. A little bit more about what should be on wage statements. Not everyone is paid by the hour. If you're paid a salary, that needs to be listed. Or if you're paid piece rate or by commission, all of it needs to be shown on the wage statement. Okay. What is also shown on the wage statement are any deductions from your wages. So the employer must show everything that you've earned, all the gross wages you've earned. Then they take off deductions, and there are mandatory federal deductions like CPP and employment insurance and taxes. Those must be taken off. And then what's left over are the net wages. So all of that must be shown on your wage statement. The minimum wage in British Columbia currently is $15.65 an hour. Okay. If you're working commission or salary or some kind of piece rate, it all must still add up to $15.65 an hour, right? So if you start a commission job and in the first month that you work there, you're not making very many sales because you're new at the job, the employer has to still pay you $15.65 an hour for the number of hours that you've worked there, okay? If you start making a lot of money on commissions, what we do is we look at the number of hours that you've worked and we looked at how much commissions you've earned. And if it adds up to at least minimum wage, good, you're covered. Okay. There are different minimum wages for resident caretakers, and it depends on the number of residential units. Those are people who take care of, rental apartments and things like that. They get a certain amount depending on how many units. There are daily minimum amounts for people who do live-in home support or live-in camp leaders, and people who are harvesting crops in the agriculture industry. It depends on the crop. They get a piece rate for different kinds of crops, and there's a whole big list in the Act about different kinds of crops and what people are paid. Now, this one here is, I don't come across this very often, but a person can't require anyone looking for a job to pay a fee for getting a job or things like that. People can't charge you. There are employment agencies out there, and if a business company is looking for employees, they may go to an employment agency, and the company will pay the employment agency for bringing you to them. You don't pay anything, okay? Now, this slide is about agreements, because in the course of the time I've worked in employment standards, I have come across so many employers who say, well, we don't pay overtime here, and all my employees have entered into agreement. They've agreed to that. It doesn't matter. Neither you nor the employee have the legal authority to make agreements that go outside the law. Everybody in British Columbia is bound by the same law, including employers and employees. So you can't make an agreement that goes outside the law. Any agreement must comply with the law. Don't forget, the Employment Standards Act is the minimum standards allowed. So you can't waive away your rights, and an employer can't waive away their obligations. Okay. We talked about things that can be deducted from your wages, so income tax and EI and CPP and things like that. But an employer cannot make you pay for the cost of doing business. So dine and dash, if somebody eats at a restaurant and takes off without paying, the employer can't make you pay for that. If you accidentally drop some dishes, well, that's just a cost of doing business for the employer. He can't make his employees pay for breakages or loss. If there's a shortage at the till or things like that, again, these are just the risks of running a business, and you can't make your employees pay for that. The employer must pay for those things. The employer also cannot make you pay for any kind of special clothing or uniforms. Okay. And a lot of employers do that. They take a certain amount off every month or something like that. Or if somebody lost their cap or their apron, they make them pay for a new one. Well, no, again, that's the cost of doing business, and the employer cannot make you pay for the cost of doing business. There are some deductions that are allowed. Now, union dues are in here, and we don't normally cover unionized employees, but every once in a while, there may be some part of a union contract that there's a little gap in there. It's missing a little bit. And in that case, if there's a gap, then the Employment Standards Act fits into that gap. So union dues are allowed to be taken off, but medical or dental plans, that's fine. Any charitable donations or pension plans, things like that. If the employer receives a garnishee from the Family Maintenance Enforcement branch, then that amount must be taken off your check. Or if you and the employer if you're working at a furniture store and you'd like to buy a couch, but you can't afford it, you and the employer might go into a written agreement to say that, $200 a month can be taken off your pay until the couch is paid for. But if you see at the top, these are written consent. An employer cannot take anything off your paycheck without your written consent. So the agreement must be in writing. It can be a text exchange, an email, or a piece of paper with writing on it, as long as there is a record of the employee agreeing to the employer removing money from wages. Okay, a little bit about hours of work that we're getting into now. There's something called minimum daily hours. So if the employer, if you're scheduled to go to work on Monday and you show up like a good employee and the employer says, you know what, we're so quiet, we don't really need you today. Why don't you just go home? Well, the employer still must pay you for 2 hours of pay because you showed up as scheduled. If the employer phoned you before you left home and said, we're really quiet, there's not enough work, please don't come in today, then they do not owe you. They only owe you if you show up as scheduled. Okay. Now that's if you're just going to work an 8-hour day. If you were scheduled for more than 8 hours and you showed up for work and they sent you home, then they have to give you 4 hours of minimum pay. Some employers know this rule, and so you might arrive at work and they'll just have you sweep the floor or something like that, anything to make up for 2 hours, because they have to pay you 2 hours anyway. So as long as they pay you for the 2 hours, they might as well use you for something, The only time an employer does not have to pay you that is if there's some event beyond the employer's control, okay? Like let's say you arrive and the place has been flooded out in the middle of the night and nobody can work that day. Or if you are unfit to work, if you show up and you're very ill and dizzy, or if you're not wearing your proper work safe boots or your helmet or something like that, the employer can send you home and they would not be obliged to pay. If we ever had a dispute about this, though, the burden would be on the employer to prove that it was discharged from this particular rule. Employees are allowed to have a meal break. Now, in the Act, there is absolutely nothing about coffee breaks. The Act is silent about coffee breaks. So employers aren't really obliged to give people coffee breaks. If they do so out of the goodness of their heart, but they don't have to. However, they must give you a meal break. You get a 30-minute unpaid break after you've been working for 5 consecutive hours of work. An employer must allow you to do that. I find this to be not a particularly strong part of our legislation, though, because many people say to me, I worked 8 hours in the day and I didn't get a break. Okay, so you worked 8 full hours, yes, and you didn't get it. Did the employer pay you for the full 8 hours? Yes. Okay, well, they didn't give you a break. That's not great, but there's really not a whole lot that we can do about that. The only time it comes into play is if you normally work 8.5 hours because a half an hour is an unpaid break. So you're there for 8.5 hours. But if you didn't get a break that day and you were still there for 8.5 hours, Now the employer owes you a half an hour of overtime because you worked more than 8 hours in a day. Okay. If the employer gives you a break, let's say that you work at the mall and you say, okay, I'm going to go my break now. I'll see you later. And you go walking away, but the employer calls you back after 10 minutes, says, oh, can you please come back? We've got too many customers. Well, now the employer is going to have to pay for the whole time because you didn't get a full half-hour break. If the employer says you can take a break, but would you mind eating your sandwich at the back of the shop or just stay in case I need you? Well, the employer is now controlling your time. So that would have to be a paid break as well. Okay. Rest between shifts. That means that you have to have at least 8 hours off between shifts. And during a week, and in the Act, a week is defined as being from Sunday to Saturday. You have to have at least 32 consecutive hours free from work each week. Okay. There's a few exceptions to that, but anyway. Overtime is a big thing. It's probably one of the main things that I get complaints about and have to deal with. So there's a lot of stuff in the Act about overtime. There's a lot of decisions been written about overtime, and most of our complaints contain some kind of overtime issue. But the overtime rules in the Act applies to most employees. There's a few exceptions. Managers are not entitled to overtime, but there is a definition in the Act about who a manager is. Just because somebody calls you a manager doesn't necessarily mean that you're a manager. We can get into that definition later. But basically, the way the Act is written is that you get paid your regular rate of pay for the first 8 hours of actual work, not break time, but work. Okay? If you work more than 8 hours in a single day, then overtime kicks in after the 8th hour. Sometimes you only work 8 hours in a day, but you might be asked to work 6 or 7 days a week. Okay? So that's why they have the 40 hours a week. So regular wages are 8 hours a day or 40 hours a week, and anything in excess of that constitutes overtime. So overtime is paid at 1.5 times the regular rate of pay, time and a half, as they call it. Okay. Sometimes we have somebody who might work more than 12 hours in a day. Well, you get your regular rate of pay for the first 8 hours. You'll get time and a half for the 9th, 10th, 11th, and 12th hour. And anything after that goes in at double time. We don't see it too often, but sometimes we see a double time thing. If you don't get 32 consecutive hours free from work each week, the employer has to pick one of the days that you worked and apply time and a half to the hours worked that day. Some employers and employees like to save their overtime so that they can take some paid time off later. That's fine, as long as it is in a written agreement. Because basically, as the employee, what you're doing is you're allowing your employer not to pay you all the hours that you earned in that pay period. You're going to bank some of those hours. But if you work 1 hour of overtime, then 1.5 hours goes into your time bank. It's banked at overtime rates. Okay. Later off sometime, you can use up the hours that you've got banked in your time bank. The employer must keep a record of how many hours are going into that time bank, how many hours you've worked overtime that pay period, how many hours are going to be banked in your time bank, how many hours have been used, and if there's any left over and employment ends, like you quit or you're fired, the employer must pay those out. At any time, you or your employer can say, you know what, I don't want to do a time bank anymore. Let's just stop this. And anything that's in your time bank must be paid out at that time. Okay. But when it comes to time banks, I have found that there's a lot of discrepancy between employers and employees. So again, I always encourage employees to keep track of their own hours of work. Write it down on a calendar. Later on, when you get your wage statement, you can make a comparison and catch any mistakes. But especially if you're banking overtime, sometimes people forget to bank it or write it down or record it. And you're thinking, wait a minute, I should have 3 or 4 days. And the employer's like, no, you don't. You only have 1 day. So it's really important to keep track of your own hours to protect yourself. Statutory holidays. Well, that for people who are eligible for it means you get a day off with pay. It's super. There's a list of stat holidays in British Columbia. There they all are. However, there's a couple that some people think are stats and are not, like Easter Sunday is not a stat holiday. It's Easter Monday or Boxing Day. Good Friday is the stat holiday. Truth and Reconciliation Day, that's a new one. And it seems like some people are getting it and some people aren't. So for now, I'm just going to say that some get that day. So great, you get a day off with pay. Well, how does it work? How much pay do you get? How does it all work? Okay, there's certain criteria that you must meet in order to be eligible. There are two criteria. The first is that you must have been on the books as an employee for 30 days before the stat holiday. And during those 30 days, you must have worked on at least 15 days. It doesn't have to be consecutive days, and it doesn't matter how many hours you worked on those days, as long as you performed work on at least 15 days during the 30 days before each stat holiday. So if you get the day off, you simply get an average day's pay. And there's a formula in the Act for determining how much pay you get. It's basically the employer has to add up your gross wages during the 30 days before the stat and divide it by the number of days you worked. Maybe you work 15, maybe you work 17, maybe you work 20. And that'll give you an average day for that particular stat holiday. But if you are entitled to the stat holiday, but the employer makes you work anyway, you still get the average day's pay like I've just described. But you also get time and a half for the hours that you work that day, all the hours, not just overtime hours, time and a half up to the first 12 hours and then double time afterwards. So it's a double whammy for the employer. It's a very expensive thing to make somebody who is eligible for a stat holiday to make them work on the stat, because now the employer has to pay both the average day's pay as well as overtime for the hours worked that day. Okay. We talked about managers because managers aren't entitled to stat holiday pay and they're not entitled to overtime, as I said before. But there are definitions, okay? So your principal employment responsibility, the reason you were employed is because you're supervising or directing, or both, human or other resources, okay? You're kind of the owner's boss at the store, okay? You're managing that business for the owner, which means you have a lot of decision-making authority. You get to decide who's going to work, who's not going to work. You're deciding what supplies to be ordered. You have a lot of authority, okay? Just because you do the schedules up doesn't make you a manager, okay? There's a lot that goes into being a manager, and the list is quite extensive in the Act. We're sort of just showing you a little bit here, but even if you're not supervising people, you might be employed in a very high executive capacity. So there's other reasons why you might be a manager as well, okay? Now, at the very bottom of this slide, it says, okay, so you're thinking I'm a manager, I'm not entitled to stat holiday pay. Well, I'm not entitled to overtime? Well, it depends on what your employment contract says. So if you have been hired to be a manager and your contract says $60,000 a year based on a 40-hour week, well, that's the conditions of employment that you agreed to. If you end up working 50 hours a week, the employer may have to pay you with some extra pay for those extra hours. It won't be at overtime rates, though. It'll just be a regular hourly rate of pay, okay? Vacation time, my favorite. All right. I am astonished at how much confusion there is out there about annual vacation time. There are so many employers who are confused about it. I have to do a lot of explaining about this, so I want to get into this bit here now. First of all employees are entitled to annual vacation pay, whether you're a manager, whether you're part-time, full-time, whether you're on call. Vacation pay applies to any wages that you earn, okay? So everybody, I've heard employers say, oh, she's not entitled to vacation pay because she's under the age of 19. What? No. Or she only is working on call or something like that. No, 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 no. All employees are entitled to vacation pay. Now, the way the vacation pay works is that you don't get it during the first year of work. You're earning it, you're accruing it, but you don't get any of it. You have to wait until your second year. And sometime in your second year, you get at least 2 weeks off. The employer gets to decide when you'll take your 2 weeks off. And you also get vacation pay because you're not working while you're on vacation. So you're not really earning wages. So the vacation pay covers the wages that you're not earning while you're on vacation. So you accrue both time and vacation pay during your first year of vacation. Okay. The amount of vacation pay you get is 4% of whatever your gross earnings are. So if you look at what your gross earnings are in the first year of employment, figure out 4% of that, and that's what your vacation pay is going to be sometime during the second year when you take your 2 weeks off. Okay. So it stays at 2 weeks and it stays at 4% until you've been there for 5 consecutive years of employment. Once you've achieved 5 years of employment, you get 3 weeks off and it goes to 6% calculated on your gross wages. Okay. Some employers give more than that, which is great. If an employer gives more than that, then that's the condition of employment they've agreed to, and we would enforce that higher rate. Okay. Well, I just talked about this, but there it is there, 4% of total wages or 6% if you've passed 5 years. And it is considered to be wages, so it falls within the definition of wages. Sometimes, you see at the bottom there, employers and employees agree that vacation pay could just be paid out on each check. That's fine. It's supposed to be accrued, but if the employee wants the money every month, that's fine too. But there has to be a written agreement about that. A lot of employers just impose that on people, and they're not really supposed to do that. It has to be with the agreement of the employee. Okay, let's talk about termination of employment. This is the number one reason for complaints, the most common reason why we get complaints. Now, the thing about termination is that the employers have the right to decide who works there and who doesn't work there. It's their business, okay? And we try not to get in the way of an employer running their business as long as they're following the rules about everything. So if an employer decides to terminate your employment, we don't care what their reasons are, as long as they follow the rules. They have the choice to provide either written working notice to let you know that your employment is going to end, or if they want to fire you that day, they can do that too. But then they have to give you pay in lieu of the notice, okay? So during the first 3 months of employment, they don't have to give you anything. They don't have to give you notice or compensation for length of service, or some people call it severance, because the first 3 months is considered to be a probation period. Okay. Once you pass that 3 months and you're still there, the employer can still fire you, but now they would have to give you notice to let you know your employment's going to end, or they'd have to pay you the severance pay. And the reason for those is so that you can financially prepare for the end of your employment. Okay. Now, if an employer decides to give you notice, everything must remain exactly the same until your last day. We get this all the time where an employer says, well, I'm going to give you 2 weeks notice of termination. And then they take that employee off the schedule or reduce their hours drastically or something like that. No, an employer can't change any conditions of employment during the notice period, okay? The other thing is that if you decide to quit or retire or something, you are not obliged to give notice. It's a courtesy, but you don't have to give notice. And the reason for that is because a lot of times an employee thinks, well, let the employer know that I'm moving on to another job, so I'll give them 2 weeks notice. And then the employer tries to terminate them right there and then. So they've kind of the employee has done themselves out of some work there, but you can stay quiet up until your last day if it's that kind of a situation. For the most part, employees do give notice out of courtesy, but you're not obliged to under the law. So we talked about how much notice or compensation for length of service is due to you. So like I said, in the first 3 months, nothing. Once you achieve 3 months of employment, the employer has to give you 1 week's notice or 1 week's average pay. Once you've worked there for a year, that jumps to 2 weeks. And after you've been there for a year or 3 years, it goes to 3 weeks. And it goes up per 1 week per year up to a maximum of 8 weeks. So even if you've been there 20 years, the most you can get is 8 weeks, okay? The employer does not have to give you notice or compensation if you quit or retire, or if they've given you proper amount of notice, or if the employer has terminated you for just cause. In other words, if you were caught stealing at work, the employer can say you're fired on the spot, no notice, no severance, get out of here. If the employer can prove just cause for dismissal, they're not obliged to give you anything under that act. But having said that, the employer bears the legal burden of proving it's just cause. So just because the employer says, well, the till was short and there was only 2 people on staff that day, and I think that this employee did it, so I fired her. Well, how are you going to prove that? You have to be able to prove it in order to get away with just cause dismissal. Okay. For a temporary layoff is not really a termination of employment. If a contractor maybe loses a contract and work is slowed down for a month or so, the employer may go to his employees and say, look, we've got a slowdown happening here. I don't have enough work for you. Would you agree to a temporary layoff? If the employee says, no, I don't agree to a temporary layoff, it's supposed to be a full-time job. Well, the employer has the choice to terminate your employment then. And since if they don't give you notice or let you work for the next, 2 or 3 weeks or however much time you get, they could just pay you and be done with you. But if you do agree to a temporary layoff, then that's fine. Then you and the employer have agreed that you're not going to come to work for a little while until things pick up. Okay. If you agree to this temporary layoff, the employer is not obliged to give you notice or pay you any compensation because you're agreeing to just a temporary layoff. But that layoff must not exceed 13 weeks. So the employer has to recall you to work within those 13 weeks. Okay. If the employer fails to recall you within 13 weeks, we will deem that a termination and severance pay will be owed. He can't give you notice because you're not at work. So in that case, it's going to be just severance pay. There are certain leaves that are protected in the Act. These are unpaid leaves. I'm sorry if the top is cut off there a bit, but it says leaves unpaid at the top. And basically, these are leaves that an employer must grant you. An employer cannot refuse to give these leaves. And once these leaves are also job protected, just because you're going on this leave, an employer can't terminate your employment or they can't change any of the conditions of employment when you come back from the leave. So there's quite a list of leaves, as you can see here: pregnancy and parental and bereavement. Bereavement is 3 days upon the death of an immediate family member, and there's actually a list in the Act that says who's an immediate family member, and it's quite extensive. It's cousins and in-laws and all sorts of things. The family responsibility leave is fairly flexible. I once had a gentleman who had to take some time off because his teenage son got into some trouble with the law and had to appear in court. So those are the sorts of things that might be, family responsibility. Jury duty is fairly obvious. Compassionate care, that one is if you have an immediate family member who is terminally ill and you need to be at home to take care of that person. There's a leave that you can take that allows you that time off. Reservist, disappearance of a child. I've never had that one. Death of a child. I've never had that one. Thank God. Domestic or sexual violence. That's a new one that's only been in place for a few years now. And that's up to 15 weeks. So a person can seek treatment and what have you. COVID-related leave, that's obviously new. That's 3 days. And if you are ill, a critical illness or injury, you can get up to 36 weeks. Now, most of these, because these are longer leaves, means that you ask the employer in writing, you explain, I need a leave, here's my reason, here's my request in writing, the employer must grant it to you. And then for a lot of these longer ones, you get a record of employment and you go and apply for employment insurance while you're on your leave. Okay, the shorter ones, like 3 days, obviously not, but the longer ones, yes. Again, it may be cut off at the top. It says illness leaves that are paid. Okay, so these are these new ones that have come in recently, about 5 paid sick days per year or 3 unpaid sick days. You get an average day's pay, and that's I did an average days pay explanation when we were talking about stat holidays. But there's, again, a formula in the Act to determine what an average day's pay is. These are employee-initiated leaves, obviously, if it's illness. The employer cannot disallow it. It's a stat. You have this entitlement under the statute, okay? And it's job protected. You can't be terminated because you had to take one of these leaves. These leaves fall within a calendar year, and in the Act, they've decided that a calendar year is January 1 to December 31. So if you started your job sometime in July, and a couple of months in, you need to take an illness leave, you still get the full entitlement, even though you've only been there for 6 months, okay? And because the sickness leave is 5 paid sick days and 3 unpaid, if you're sick a day and you don't want to use one of your paid sick days, you can say, please just use one of my unpaid sick days. You can choose which of them you would like to use, okay? When the employer is doing their payroll that pay period, they're the ones who must ensure whether that was a paid day off or an unpaid day off. They need to clarify that, okay? But I always say to employees, for heaven's sakes, send a text or an email and put it in writing yourself. Those texts and emails are always great because later on you can go back and say, no, this is what we said, or this is what I said, okay? Illness leave does not carry over from year to year, okay? If you didn't take any illness leave that year, it's gone. Next year, you start all over again, okay? If it's a stat holiday and you're called to work, but you're ill, the employer will still owe you stat holiday pay as well as the paid average day for a sick day, okay? Sick days are considered part of your wages. They fall in with, they're entitled to vacation pay calculations and everything at the end of the year. No partial sick days. If you're going to call in, it's a day. It's a day's thing, okay? The employer does have the right to request some kind of reasonably sufficient proof to show that illness or injury is the reason for absence. Now, that whole language, reasonably sufficient proof. Well, some people say, well, that's a doctor's note. You have to go to the doctor and get a doctor's note. No, it's not necessary to do that. It can be any kind of information to establish a reason for the absence. I had a really sore throat that day. I didn't want to go into the doctor's. I was worried about testing positive, and I needed the day to take it off. It's just anything at all that if you just simply say the reason why, it should be enough. Okay. But if you have something that can prove it, if the employer is really giving you a hard time and you want to keep good relations, it's fine. You go and get something then, like something from the pharmacy or doctors or something like that. Okay, a little bit about employing people in British Columbia. There are a couple of rules about employing kids, right? So if a person is under 15, the parent or guardian must give their written permission to the employer to hire that child. Okay, so a person who's a minor under the age of 15 is considered not old enough to make a responsible decision, which I think is a little off, but whatever, that's what the rules say, okay? If a person is under the age of 12, then there's a very special permission that must be sought from the Director of Employment Standards. And in that case, somebody like me would be sent to examine the workplace to make sure there's no, boiling vats of oil or sharp knives or things like that, or any kind of danger. This kind of permit is very rarely given. It's sometimes given if it's a family business and the kids are working with the mom and dad or something like that, but it's very rare, okay? And there are also very special rules for kids in the entertainment business because sometimes, shooting a film or a commercial or something like that, there are some very long hours involved. And so there are very specific rules about how long a child can work in any one day. It's much less than 8 hours in a day, but there are certain rules about all of that. Okay, so you're at a new job. Congratulations. Like I said, please, please, please keep a record of the hours you work yourself. Don't rely on the employer or someone else to do it for you. Do it yourself, just to have a calendar at home and just jot it down at the end of the day how many hours you worked that day. Keep your copies of your wage statements and keep any correspondence with the employer. Texts and emails are important because later on, if it's a he said, she said, if there's a text that supports what you're claiming, it's very helpful, okay? It's important that you understand your rights and also what the employer is obliged. There's a lot of employers out there running businesses who are very unaware of the rules. They think they understand it, but they actually don't. So sometimes it's good if you have a really good understanding and you might point your employer in the right direction. Don't be afraid to raise questions or concerns with your employer. It's a legal relationship that you're in. Okay. The employer has rights and obligations, and you have rights and obligations. So don't be afraid to raise questions or concerns. And if you and your employer are having a mild dispute, it's not a big dispute, but you both sort of think you have a different understanding of it, call employment standards. There's an information line, and you can just ask the question there. The employer is entitled to expect that you are going to try to be a good worker. You're going to be on time. You're going to be productive. You're not going to cause problems. He has the right to, if he's hired you and paid you, yes, you must be paid for the hours that you work, but there are things that you must give back to your employer as well. Okay. If you've got a dispute with your employer and the two of you can't seem to work it out, then you can file a complaint with the Employment Standards Branch. Okay. Your complaint must be in writing. And when it says delivered to an office of the Employment Standards Branch, as the next line, it can be online, mailed, faxed, delivered by hand, any way at all, as long as you get it to an Employment Standards Branch office, okay? But there are timelines, and this is very important, okay? If you're going to file a complaint, you must do it within 6 months of the last day you worked there. Or if you're still working there, you have to do it within 6 months of the date of the contravention. We have people who were fired from their job in July and they didn't get any notice and they didn't get any severance and they don't agree that the employer had just cause for termination, but they waited until the following March to file a complaint. And unfortunately, that means that they're out of time and we can't do anything about it. So if you're going to file a complaint, or if you know somebody who's maybe thinking about filing a complaint, maybe let them know that there is a 6-month deadline for doing so. If we do get a complaint and it's on time, we will look at whatever wages may be owed to you going back over the last 12 months of your employment. So if it's, for example, an overtime complaint or statutory holidays or something like that, we will go back 12 months from the last day of work or from the date of the contravention, and we'll go back 12 months and look at it all. We don't have enough staff to just go out there randomly and check in on employers and things like that. Unfortunately, at this point in time, we are complaint driven. So we do something when we receive a complaint from somebody, okay? The complaint process is free to the party. You don't have to pay anyone anything to file a complaint or have us deal with a complaint. I'm an investigator and I remain neutral, which means I don't act on behalf of the complainant and I don't act on behalf of the employer. My job is simply to gather information from the person making the complaint, evidence, anything they have, they want to support their allegations, and I gather information from the employer and I provide each party's information to the other party so that everybody knows what's on the table. I see if maybe we can try and find a voluntary resolution, okay, based on what I'm seeing on the evidence. And if there doesn't appear to be any way to resolve this, then at that point, the branch is going to have to issue a formal decision on the matter, okay? During this entire process, if English is not your first language and you want to make sure people are understanding what you're saying, you have every right to bring an interpreter along, and that person can be on the phone calls or can respond to emails on your behalf. But yes, you can have an interpreter. Okay, so like I was saying, I just gather information from the parties. And I also try to help people understand the act because sometimes employers will say, well, he's claiming for overtime, but we don't do overtime here. And I have to explain that, yes, you have to pay overtime and things like that. So I do try to help everyone with some education and information and things like that. I am not a decision maker. I'm an investigator. We have different roles at the branch. So I'm the one investigating. I'm gathering the evidence. I'm talking to the parties. I'm explaining the rules and the regulations. and I'm trying to find a voluntary resolution. If it can't be done, if the parties can't resolve it or refuse to agree, then I'm going to write a report, okay? And I'm going to say, this is the issues, these are the parties, and here is a list of all the evidence that they submitted, as well as what they said, everything that's on the record. And I'm going to forward that to the parties so that they can both check it and make sure I've got it right and I just didn't misunderstand something. And once they say, yes, it's good, then the whole report goes to a branch adjudicator. An adjudicator is a decision maker. That person will write a formal decision, we call it a determination, and that determination will decide whether any wages are owing, and if so, in what amount. Also, that determination will say whether the employer has contravened any part of the act. If any part of the act has been contravened, there are mandatory penalties assessed against the employer. Okay, so I always say to the employer, before you let this go to a decision, are you sure? Because I'm not the decision maker, but if it looks like some wages may be owed, you might want to clear that up. Because if it goes to the decision stage, not only will those wages be owed plus interest, but there may also be some hefty penalties coming your way. So I always sort of give the employer a chance to clear it up voluntarily so that we don't have to go to that decision stage. Okay. If a decision is issued and the employer is told you have to pay X amount of wages, and the employer ignores us and just doesn't, we do have a collections department, and that collections department is authorized to go after the personal assets of the employer, the business assets, as well as the personal assets of the owner. The penalties for contravening the act are here in this list. For the first time, it's 500. If you do the exact same thing a second time, let's say it's overtime, and you've been educated about it, and you don't pay, you'll get a $500 penalty. If I get a second complaint about overtime, you were educated the first time, so you're going to get another penalty. This time it's 2,500, and then we go to 10,000 if it's for a third time. There's only been a few $10,000 penalties in the history that I've worked at the branch, but it does happen. There's a website for the Employment Standards Branch. You can get general information. There's something there called the Interpretation Guidelines Manual. And that, if you go to the website and just try and look for that, that's kind of like the Act explained, because there's the legal language of the Act, which is dry and hard to understand. And the Interpretation Guidelines Manuals is good because it'll quote the Act, and then beneath it, in English and regular language, it'll explain that part of the Act. It'll give examples and things like that. So it's very good to go there and have a look yourself, but you can also call the 1-800 number. It is populated by actual human beings. So you can speak to somebody, you can explain your situation, and that person has knowledge of the Employment Standards Act and can try and explain it to you. They can also help you a little bit if you want to file a complaint. They can show you where to go and what to do and that sort of thing. Luckily, things are online now. We used to have a lot more offices all across the province, but many years back, they kind of put it down to 10 main offices around the province. But everything is done online these days. So, oops, that's the end of the slideshow. Everything is done online these days. So we're doing everything by phone call and by email and that kind of stuff. But you can still go into an office. I don't know why my slide doesn't contain them, but there's an office in Victoria. There's a couple of offices in the Lower Mainland. There's one in Kelowna. There's one in Prince George, Dawson Creek, things like that. So you can always go into an office if you really want to. And that is it for me. I need to take a drink of water now and listen to some questions if there are any. Thank you.
Oh, thank you, Kathleen. Such a in-depth and thorough presentation there. Yeah, it's this is like my third or fourth time participating in these sessions, and I learn something new every time. So thank you for that. I have a couple of questions here. The first question, just as a general thing, is it possible to share the slides of this presentation?
Yes, I'm fine with it. The information is public information. There's nothing there that isn't public. So yes, of course.
Okay, awesome. So in that case, I guess we would be able to connect with Mike, I guess, and then we'll send it out from there, kind of
Sure.
thing.
Yeah,
Okay,
that's fine. Yeah.
awesome. Mike, you hear that? You good with that? Okay, so that's the first question.
I'm great with that. Yeah, I'll put my email in the chat, and if anyone wants to have access to the slides, they can email me and I'll make them available afterwards.
Oh, thanks a lot, Mike. That's awesome.
Thanks.
I just have a question about, you'd mentioned going in, and part of your role is going in and looking at workplaces for those that are under 12 and that kind of stuff.
Mhm.
Where does your work end and where does WorkSafe begin? How does that?
Well, that's an interesting conversation. I have only ever once had to go and do an investigation for an application for a child under 12, and that was on a farm. It was the dad. He just decided that for the summer, might as well put the kids to work picking up rocks, that sort of thing, pay them and, start teaching them about that kind of stuff. So he put in an application and I was sent to have a look. So really, I mean, the dad showed me around the farm, and the job that he was going to have his 10-year-old kid do was basically just sort of picking rocks up, out of the field and things like that. But we did have to have a conversation about hours of work and things like that. And he put in writing what conditions he expected his little boy to work. A few hours a day, at this time of the day, and these would be the tasks that he would be doing, and that sort of thing. Now, if I went there and a child would be going to be expected to work around what I thought was dangerous, something like that, I would contact WorkSafe BC and ask them to go and have a look at it. The Director of Employment Standards is the one who will issue a child work permit, and I have never seen one issued.
Okay. Well, that's pretty strong then. Never happened.
Yeah.
Okay.
It's probably different for the film industry is like its own universe. So there are some special rules in the film industry. And that's like I didn't go into it in this presentation because it's so complex and it's so separate from the real world in every way. So yes, children obviously do work in the film industry, and there's just an absolute whack of rules there. And I'm sure WorkSafe is involved in a lot of that too.
Okay, awesome. Because I was like, oh, okay. So it seemed to me that you were sort of before you check it out beforehand, and if there were some issues, then WorkSafe would take it over afterwards. If there was
that's the process, but I've only ever once, and that must have been 15 years ago, gone and actually looked at a workplace. And
okay.
even in that mild sort of a situation where dad just wanted the little boy to pick up rocks from the field, the director denied it.
Okay.
So there you
Oh
go.
no, it's great to know. I'm glad to see that there's not a lot of 10-year-olds out there working.
No, it's
right?
yeah. I don't think the director wants there to be a lot of little kids working. So
So Vanessa has a question. For firing an employee, does there need to be a certain amount of warnings, either written or verbal, and employee needs to be aware of them?
okay, that falls into the termination for just cause. There's a lot of stuff in there about just cause, because just cause can be a one-time event, like you were caught stealing, or you punched somebody, or something like that. But it can be a progressive discipline issue. So if an employer, let's say that you're coming in late all the time, and the employer gives you a written warning and says, look, you've been late several times in the past few months. It has to stop. This is your written warning. If you're late even one more time, it could be rules or grounds for termination of employment. And then a month later, you come in late and the employer fires you. Well, you have been given a written warning. It's the same as being given notice of termination. Do you remember how I said the employer can decide to let you go and they just have to give you a week's notice or 2 weeks notice, however long you've worked there? That's written notice of termination. So if you've been given a warning about something, that's the same as written notice. You're on thin ice, and the employer has warned you in advance, so you can't say you didn't know.
Is there an obligation to give written notice before termination, though?
You mean notice of
notice of warning, like a warning?
Of warnings and things like that. Well, the employer bears the legal burden of proving what its just cause is. So in the example I gave of somebody calling in late all the time,
Mhm.
coming in late all the time, the employer may give you a written warning saying, if you come in late one more time, you could be fired. And then a month later, you were, I don't know, caught using your cell phone on the floor, and the employer fires you and said, well, we gave her written warnings. But the written warnings are not the same as the reason for the termination. The written warnings the reason for your termination have to pertain to the written warnings you gave.
Okay.
So you can't
So-
mix and match. But the employer, if the employer just fires you one day and you didn't receive any kind of written warnings or anything,
Mhm.
the employer will have a very difficult time proving it's just cause.
And then there would be a sense for severance or, that
Correct.
piece then. Okay.
Correct.
Cool.
So a lot of people, they make a complaint saying, I was terminated from my employment. The employer said he had just cause to do it, but I think I'm owed compensation for length of service because I never had any written warnings. It came as a surprise. So when I talk to that employer, he'll say, well, we did say something to him. Well, the adjudicator wasn't there to hear the conversation.
Okay.
So it's up to the employer to prove it. So it's up to the employer to put things in writing and follow up with things.
So it would be in the best interest of the employer to provide some written warnings ahead of time, but it's not
Exactly.
necessary. But it's not necessarily a need.
No, and sometimes an employer will do that when you first start working at a job. An employer may give you, when you sign on all the paperwork and everything that you sign at the beginning of a job, there may be a policy handbook or rule book there, something like that, where the employer has listed things. No using your cell phone on the floor. This is a non-smoking building, or this or that, and any of the infraction of these rules could result in termination. Well, you might work there 3 years and then get fired for something that was in the rule book that you got when you first started working there. You did receive written warning at the very beginning of your employment.
So that's really good to know when you're signing those papers at the beginning to understand
right.
what you're signing, because that
Mhm.
can be used as written warning. Okay, awesome.
Correct.
Thank you for that. That's definitely something I just learned. So thank you, Kathleen. Vanessa was following up with the question, is there a penalty on top or just severance if someone doesn't give you written warning?
If somebody doesn't give you any kind of written warning and they're not able to prove just cause, we're going to make them pay compensation for length of service. And the amount they have to pay depends on how long you work there. It's just simply the formula found in the Act. The only time there's anything more added onto that is if the employer refuses to pay it or disagrees and insists that they somehow had just cause, or if they're, they think that they have proof, but it's not very good proof. An adjudicator may write a decision against that employer and say, you know what? No, you do owe compensation for length of service. And not only that, but you're going to owe interest. We actually have interest under Section 88 of the Act, because sometimes it takes a year or so before the person gets their money.
Right.
But that interest only ever applies if we have to write a decision, and the interest is not very much. So it's not, it's not really worth it to make it go all the way to a decision just for a tiny bit of interest.
But aren't interest rates up right now?
It's not that kind of interest.
Okay. Thank you for that. Vanessa, I hope that answers a lot of your questions there. I have a question. Oh, not a problem. I have a question just around Employment Standards Branch and human rights. And if you feel that you're working and something comes up where it's infringing on your rights, do we come to you for that?
Okay, so the employment standards legislation is actually quite narrow. We legislate hours of work and wages. So we don't really deal with health and safety issues. The only thing we deal with health and safety or health is now this new sick pay thing. But again, that's really about wages, right? We don't deal with health and safety issues. We don't deal with human rights or, bullying, harassment, things like that. We really are quite narrow. It's just, how many hours did you work and did you get paid properly for it?
Okay, I love it, because I do think that when I talk with clients, definitely, something's coming up where they're concerned about human rights and where they want to go or where we
Right.
should send them, or so it would be the Human Rights Board then at that point.
Correct.
Okay,
That's correct.
Awesome.
Yeah.
Awesome. Just for everyone out there, if you have any questions, please type them in the chat. I know we've had some conversation and lots of information was presented today. And I know we're processing some of that, but there's anything that now's the time. We have Kathleen for the next 17 minutes with us. So if you have any questions, please feel free to toss them in there. Yeah, always wanting to know what you're wanting out there and what kind of questions are you needing answers to. Yeah, so Kathleen, right now there's no other questions out there.
Oh, wow.
But you mentioned that termination was probably the thing that you get, that's the most common complaint
Right.
that you have. What within the termination, like what kind of termination without cause, that kind of stuff, or?
Yeah, usually it's that kind of thing. A person has been terminated and the employer believes they have just cause. The problem with just cause is that it's actually kind of a very legalese sort of a term. Employers think that, well, it's just common sense. He swore at me. So common sense says I can just fire him on the spot. Well, not really. Maybe you don't like maybe if you're an employer, you don't want somebody to swear at you, and I don't blame you for that. You can decide maybe to let that person go if you don't like their attitude and just give them their proper notice or pay them compensation and let them go. But if you expect to fire somebody on the spot, you're going to have to prove that what the employer has to prove is that the employee knew that if they did something, it could result in termination, but they did it anyway. You almost have to be able to prove what the employee's state of mind was. And that's very difficult to prove. So I always kind of warn employers off of that. If you don't like that employee, you don't like their attitude or whatever, you have every right to let them go as long as you follow the rules, like give them proper working notice or compensation and let them go. You don't have to have that person working there anymore. But if you're going to fire somebody on the spot, you're going to need to prove to me that that employee knew they could be terminated for doing A, B, or C.
Okay, awesome. And just as clarification, after termination, you have 6 months to file a claim with employment standards.
That's correct, yes.
Okay.
And we go right to the actual day, the date, the 6 months from your actual date, your last day of work. Occasionally, we have people who are still employed at the job. They think their employer is doing something wrong. Like they've had a bit of an argument with the employer about, like, say how they're doing, I don't know, stat holiday pay or something. And the employer says, no, I'm doing it correctly. No, I'm doing it correctly. Or my payroll person tells me this is the way to do it. So this is how we're going to do it. Well, sometimes employees are still employed there and they'll put in a complaint saying, look, I've talked to my employer. I've told him I'd like to ask employment standards. I think I may be owed wages for stat holiday pay because I think he's doing it wrong. So we'll say, okay, when did the most recent contravention occur? When was the most recent stat holiday? And we'll go 6 months from that latest contravention.
Okay, awesome. Yeah, and again, that's, I'm thinking like March 14th, then it's September 14th, and that's it. September 15th, you're not eligible.
You're a day late. Now, if somebody did, like a lot of people don't know about employment standards, and then they find out about it, somebody tells them about it, and they're thinking, what? I should file a complaint. And they might be so close to the edge there. If they're a couple of days over, maybe even a week or something over, I always tell people file the complaint anyway. Because if it's late, we have to jump through a few little hoops. We have to tell the person you're late, you're out of time, but they can do a special application to the Director of Employment Standards and explain what extenuating circumstances there were that led to them filing it, past the 6-month dedeadline. It might not work. Usually it won't work if there's no particular reason why. They just didn't know about it. But if they were like, in the hospital, because there was something like that, or they couldn't do it because of some reason, if they had to leave the country or something along those lines, like we may look at it, we may extend the deadline. So some people have put in that application asking the director to please extend the deadline because of these special circumstances.
Okay. So again, it's not absolute cut and dry. There is a way around, but you have to, again, show just cause for not going within the.
Well, the application to extend basically asks the question, can you please provide the reasons why you were unable to file a complaint within the 6-month time period?
Okay.
What's your reasons? You can put down your reasons, and we get many reasons. I didn't know about the act.
Right.
I was waiting for my employer to send me some money and he just didn't, or whatever. There's a whole bunch of reasons, but very few of them will fly.
Okay.
You know,
It's
because
pretty distinct as to what allows that extension to happen.
yeah, because 6 months is a long time, and if you haven't filed a complaint within 6 months, you know, it actually, after 6 months, it starts getting more and more difficult to go back and find evidence, because if there's one thing I should tell people, if you filed a complaint with us, we have a complaint queue, and files are assigned to officers like myself on a first come first served basis, and we have quite a long queue. So I'm, for example, where are we now? We're in October. I'm dealing with complaints that were filed back in May.
Oh, wow.
Right? So that there's that much of a deadline. So sometimes by the time I'm talking to a person, they may have filed their complaint way earlier than May, you know. I'm saying, oh, well, do you have the text messages, or do you, oh geez, I don't know where those are anymore. I've lost them, you know. So I always say to people, you know, just to protect yourself, you want to hang on to certain things, and you know, that way, if because some employers are very uncooperative with us, and we ask them for pay records and time records, and they just either didn't keep them or they refuse to give them.
Okay.
So now, if somebody files a complaint, they are essentially making an allegation against another party. And in the law, there's something that says he who alleges must prove. So in case I can't get anything out of the employer, I may turn to the complainant and say, do you have anything to support your allegations?
Right.
And it's really, that's why it's so important for employees to hold on to their wage statements or any, you know, contentious emails or text messages or something, because it may come in handy later on.
Okay. Yeah, no, I can definitely see that. And I'm just thinking, you know, if you know, something happens, say March 14th, you wait till September 13th to file a complaint, then it falls into, so it's already been almost 6 months, but then it falls into queue. So that complaint might not even be seen until the following February.
That's
right?
correct.
Like, yeah. So it is a process, definitely. And that evidence, and everyone knows evidence gets colder the longer it stays.
Exactly.
Right?
Yeah,
so,
exactly.
Okay. Well, thank you for that. Vanessa was wondering, if someone is laid off, is there a period of time the employer has to observe before they could hire someone else?
Well, the job is yours. If the employer is hiring somebody else, who cares? He still has to give you your job back. If the employer does not give you your job back or doesn't call you back to work, then you have been terminated and the rules of termination apply. Obviously, you're not at work, so he can't give you 2 weeks or 3 weeks notice. Right. So he's going to have to pay compensation for length of service at that point.
Okay. So again, like they can hire someone else if they want to, but you know, when it comes to you, you would then, if they've not hired back, you would then be terminated and then subject to the compensation with that.
That's correct. That's actually correct. Yeah.
Awesome.
The other thing about being away from work, let's say you're on a leave, perhaps a parental leave or something like that, and you're away. When you come back to work, the employer has to give you the same conditions of employment you had prior to the leave, as best they can. I mean, if the place burnt down and they had to move to a new location, well, obviously something has changed there, but or if they've lost some major contracts while you've been on your pregnancy leave or something, and they had to shift duties around. If there's a good business reason why they had to change some things, that's fine. They'll have to show me their business reasons. But if you go back after a pregnancy leave and they like the replacement better than you, and so they give you a lesser job or lesser hours or lesser pay, that's a problem. They have basically changed the conditions of employment and they can't do that. And we would actually look at that as a termination of employment, because the job as you knew it is no longer.
Okay.
They've given you a whole new set of conditions, which is essentially a new job. So we, at that point, may make the employer pay compensation for length of service.
Okay, I love that. Again, stuff you don't know. And well, one question I have, and it was sort of came up earlier when you were talking around the 4% for holiday pay, and how some employers try to sneak that onto your paycheck weekly or biweekly instead of accruing it. If you were not hired and the employer is saying, this is what we do, we supply it every paycheck, you're like, actually, the Employment Services Branch says it has to be accrued. And they go, well, if you don't like this, then we won't hire you. Is there any, is that an employment standards piece?
Not really, because everybody in the world has the choice of whether they want to take a job or not. That employer probably needs a little bit of a lot of employers do this. A lot of employers don't realize this, that it's fine to have vacation paid out with every pay, but it's the employee who should request it in writing. Then the employer can pay it out on every pay. A lot of employers aren't even aware of that. And for the sake of ease of payroll, they just simply do it with everybody. And most people are just like, fine. The problem with that, though, is that, like I said, vacation comes in two parts, vacation pay and vacation time. If after the first year, now you're still there, you get 2 weeks off, but technically you don't have any pay during those 2 weeks.
Right.
So it's not great, right? So that's why it's up to the employee to request that if they really want the extra money every month. But as long as they understand that when their vacation time comes around, they'll be, they won't have any money to eat with while they're on vacation.
For those 2 weeks, for sure.
Yeah.
Okay. Thank you so much for your time today, Kathleen.
You're very welcome.
I really value when we have people come in and talk with our clients and people in general just about what their rights are and what you're entitled to and what your workplace should look like and the things that should go on there. And so I thank you so much for coming in and sharing your knowledge with us.
Oh, you're very welcome. I enjoyed giving the chat. I haven't done this for a long time, so it was good.
Oh, it was awesome. You were like such a pro. It was so good.
Okay.
Everyone, before, as we're signing off, if there's any questions, follow up, last thing that you want to put out there, let me know. I see everyone's giving you thank you, Kathleen.
Thanks, everyone.
Yeah, lots of great information. And Miss N. Burns says, I appreciate the contact information and thorough slides. So yeah, I think again, people are appreciating the information because this is not information that, again, everyone knows about. And I think a lot of people don't know about the Employment Service Branch and what you do and how you can really help everyone else out.
I know we need to advertise more.
Don't we all? Thank you so much.
Okay.
As Mike put into the chat, this presentation will be available for the Work BC clients on Client Connect, Career Connect. So, go there if you would like a copy of this. And again, send Mike a message in the chat if you would like a copy of the slides today. Kathleen has been very generous and is offering them up to us. So thank you so much. Thank you, Kathleen, for again being here today.
Okay.
Mike, thank you for putting this together. Alice and Marissa, thank you for transcribing today. Everyone, thank you for spending the last hour and a half with us today. And I hope the rest of your day is great. Have a great one. Take care.
Bye-bye.